good evening, everybody. Jonathan here. Hope you all are doing well and are staying warm. Obviously, it's not this ridiculous cold we had last week. It's warming up here in Atlanta, so I hope it's warm where you are as well. What I'd like to do tonight, I know we've got a lot of questions already queued up, but I know last week there was a lot of discussion about this emergency message from Social Security, and at that time last week I had not really had a chance to look at it or really get any sense of what it all meant. I've had a chance to look at it, and it's pretty straightforward. I want to go over that with you, and then we'll go through this emergency message. Then we'll go through, go to the questions we normally have. So let's go ahead and start by going through the emergency message, because I know people do have questions about that. So here is what the emergency message looks like. This is emergency message 25009. And if you don't know what an emergency message is, when Social Security wants to get a policy out quickly, they use this, they call it an emergency message, to give Social Security employees and decision makers, pretty much an immediate directive to do something. And so basically what this does, and the basis of it is, if you look at it, and again, I'll put the link in the comments here. Let me go ahead and do that. So if you want to look at it, you can. What this does is it recognizes that there is a huge backlog. And in fact, it even says here, the background is because of the claims backlog of 1.12 million cases. And just to give you an idea, 15 years ago, 500,000 cases was an unacceptable backlog. We've got more than 2 times that many right now. And so what the issue is that normally in a Social Security case, when you file an application and a claims specialist or adjudicator is assigned to the claim, so again, it goes from Social Security to the state where you live, and an adjudicator in the state office, which is funded by the government, federal government, but is technically employee of the state. This person, called an adjudicator, will request medical records, gather those medical records, review them, and then send them to a medical consultant that works for the state agency. And the medical consultant will offer an opinion. It will come back to the adjudicator. The adjudicator will then make a decision. Well, what this emergency message recognizes is that Social Security does not have enough medical consultants. So in other words, there's not enough medical experts or doctors in many Social Security offices to properly evaluate these claims. And so what this message says is that in some situations, adjudicators with a lot of experience, more than a year of experience, and there's some other training they've got to go through, can make decisions without having to go through the medical specialist. And so what the practical effect, in my opinion, is going to be is that claims, and this only applies, by the way, to physical impairments. It does not apply to mental health impairments. It's physical impairments. So what I think the effect's going to be is that if you have back problems and you're over 50 or over 55, and it's a clear case of, you're not able to perform work because of a really bad back, the adjudicator can make a decision without running it through the medical specialist. The goal is to speed up claims processing and to make this backlog go down. Now, it only applies, again, for physical impairments, number one. Number two, it only applies if the adjudicator can make a fully favorable decision, does not allow the adjudicator under this scenario to change the onset date, which, again, sometimes they do. They'll approve you, but they change the onset date. That's got to go through the normal process of having a medical expert look at it. Number three is it only applies if there are not enough medical experts in the office that's adjudicating your claim. And they've not given us any specific metrics as to how to know if there's not enough. My guess would be that, if let's say there's X number of claims and a certain number of medical expert hours, and the number is it's too high, then they'll say, we don't have enough. We're going to let these adjudicators make the decision. The fourth thing is, I think I'm on number 4, is this is only going to be in effect for 2 years. Now, it may be extended, but right now it's for 2 years. This looks suspiciously like something that Social Security did 20-something years ago called an adjudication officer, which is sort of a specially trained adjudicator who had more power than regular adjudicators to make favorable decisions. So again, it doesn't apply in every single case. It does not apply at recon. It does not apply if you have mental health issues. It only applies, doesn't apply if it's a if you're trying to reopen a case. So it's only for initial applications, the first time, physical impairments, where there's not enough medical consultants to make a decision. And again, this will allow Social Security to approve cases that should be approved quickly, more quickly. Obviously, everybody benefits when the backlog is reduced. So we'll see how much effect this really has. I don't really know, but this is kind of what this says. Now, I do want to show you something kind of interesting, and this is, let me go ahead and share this. Let's see here if I can do this. May have to stop sharing, then go back and share again here. This is the comment section from Charles Hall's blog, and Charles has a Social Security blog that he's very opinionated, and he talks, he had an article about this emergency message, and some of these people had some interesting comments, and this one I thought was particularly interesting. This is a former adjudicator. The system worked well when we had it before, again, like the adjudication officer. His or her comments: medical consultants take forever to review cases, and in my experience, typically don't do a very comprehensive job because they're paid a flat fee per case reviewed, and there's no incentive for them to actually review everything as thoroughly as they could. I expect this will be a positive change for deserving claimants. They're using seasoned adjudicators for this work, and they're at least as qualified as administrative law judges to make these decisions. So, that's a real positive type of thing. And again, you've got somebody else says we used to be able to do this certain impairments, essentially, but this person said, gave an example of a newborn with very, very low birth weight, but they took that away when there was an increased approval rate, but there was no increased error rate. So again, a cynical former adjudicator says, when Social Security saw more approvals, they took this away. So again, we're going to see how this, if this person says this is illegal because of some internal Social Security policies that require them to use a medical expert. So again, you're going to have all over the map here about, and there's also some discussion about telework, and that's another big issue right now, is that the Trump administration is requiring people to come back to the office, but Social Security Union had already negotiated telework, so we're going to see how that comes into play. So the point is we're not exactly sure how this is going to all shake out. I think my guess would be, again, that what we're going to see is the more obvious cases, specifically severe back pain cases for older people. I think we're going to see more rapid approvals there. And again, people over 50 is probably going to be the most of it. You may see some younger people as well, but obviously the ones over 50, the grid rules apply. And so I think that's what we're going to see. So it's just going to mean, and again, I look at it from the point of view of, I take cases in and I look at these cases like, this person ought to get approved quickly, and hopefully they will get approved quickly. And I'm going to change my procedure where when I'm doing an application and it's a case that should be approved quickly, I've got some language to ask them to have this case be part of this program. So that may get me more early approvals, which I would love to have, because again, the faster we can get these cases approved, the happier my clients are going to be. So that's what this emergency message, I think, is really all about. Again, we're going to see how it all plays out, but I'm hopeful that we're going to see at least some increase in favorable decisions for the more obvious cases, and correspondingly a reduction of the 1.2 million backlog. Now, we still have a big backlog at reconsideration, which this emergency message does not impact. And in a year or so, we're going to have a big backlog at the hearing stage, where Social Security is down about half as many judges that they had 10 years ago. So, we're going to have another problem at that point. Right now, it's pretty quick to get to a hearing. because the judges are not overworked. But when all these cases that have been building up start being processed through the system, we're going to have a problem with getting cases decided by judges. But we'll tackle that problem when we get to it. But I think the takeaway of all this would be, if you have a physical impairment that is really, really clear and you're over 50 and you're thinking about applying, go ahead and do it. I think that we're going to see more early approvals, which I think ultimately is a good thing. Okay, so that's my take on that. Welcome any questions, but that's what I think we're going to see. Okay, let's go to some of the questions that we get and we'll address. Gary English says, good evening, sir. I'm just Jonathan, not a sir. SSD is now asking me to go to a CE or consultative evaluation appointment after almost a year and a half. I have to have a general medical and x-rays of my cervical and lumbar spine. Should I bring my MRI reports or disc? I think you should. Now, again, we had Dr. John Foster on a couple months ago. He said, he's not a big fan of having people bring their MRI reports and discs. I don't think if the CE doctor doesn't want to see it, they'll tell you, but my feeling is that that's information that could be valuable and useful to the CE doctor. So why not bring it? If they don't want it, you've got it. So I would say, yes, bring it. And he says, my first report and disc are before surgery of December of 22, then long after surgery in October of 23. Yeah, I think you bring both of those. And again, this is part of the record. In my opinion, the more information the consultative doctor has, the better. So that's my take. And again, Dr. Foster feels differently, but I think the more information you give them, the better. Eunice Salah, thank you very much. You're very welcome, Eunice. I hope you find this useful. Blues City Garage. It's been 1.5 years since I initially filed, and you see, people always ask on these live streams, how long is this going to take? And my feeling is, generally speaking, it depends on the state. It's going to be 8 to 12 months at initial. It's going to be 7 to 11 months at recon, 5 or 6 months at a hearing. But in some states it's a lot longer. And Blue City Garage, I'm not sure where that is. You in Memphis, I don't know where Blue City would be, but it's been 1.5 years. So this is taking much, much longer. And by the way, if it's taken 1.5 years, I think you ought to reach out to your U.S. Senator's office to do a congressional inquiry to find out why it's taking so long. Anyway, Blue City, it's been 1.5 years since he filed, he or she. I was sent for a chest x-ray and an EKG, have an appointment with the CE for consultative internal medicine. Is this normal? It's normal in that, they would send you out for x-rays and maybe an EKG. They don't do MRIs or CT scans. So that part is normal. It is unusual that it's taken this long, but it is normal for them to send you out for these, these type of tests don't really tell that much. Obviously, an x-ray is going to show a broken bone. It's not going to show soft tissue injury. But, again, it gives the CE doctor something to look at. My experience has been that physical medicine consultative evaluations have marginal value. A lot of times they're done by industrial clinic doctors whose main focus is to find you not disabled because they work for insurance companies, whereas the mental health consultatives typically offer a little more comprehensive evaluation by a psychologist who actually is in practice. But again, you've got to go to them, and every once in a while you get surprised where the physical consultative comes back and it eliminates categories of jobs by finding some level of impairment. But again, you got to go through it. But I think that most judges recognize they're not all that valuable. Although, again, if a judge wants to deny your case, he or she can use the consultative report to do that. Or for that matter, they can use the medical consultant's report, the person who never saw you that just looked at the record, they can use that as well. So judges have a lot of tools at their disposal if they want to turn you down. But yeah, I think you got to go to the consultative evaluation and hope for the best. T.E.M. Jr., do you recommend bringing your emergency room records to this physical exam, Tom, in Galveston, Texas? I don't know that the emergency room records are going to be all that helpful. I mean, they take a history. I think objective tests would be more valuable. My feeling would be if you've got them, take them. Let the doctor know that you've got them. These doctors don't get paid a whole lot of money. They're not going to spend 2 hours with you. But they take a history, and if you look at these reports, it'll say claimant reported that he was in the emergency room, for 3 hours, 2 months ago, and they may add to that, he brought those records, and I reviewed them, very briefly. So again, I would have them, but I don't know that you're going to really get much. There's not going to be really a whole lot done with them. But again, I think that's that would be something just to have in your back pocket if the doctor wants to see it. And Blue City, by the way, says he is 60 years old. He was 58 when he filed, and obviously that says to me, and since they're doing X-rays, I'm assuming you have physical limitations. Then I would tell you the grid rules. Take a look at gridrules.net. I'll put that up here. The link there. Look at grid rules, like 202.06. And you may find that that could really benefit you, because anybody over 55, I think, should look at the grid rules if you've got a physical type of impairment. Don Best says, my medical is complete, sent back to the local office for final check, called and they told me I was approved. Excellent. Any chance they'll deny me at a final check has been since January 17th, have not received a letter. I think it's unlikely, but it is certainly possible. Until you get that letter in your hands, don't start spending the money. But normally, if they've gotten the favorable medical review, what they're going to look for now is any evidence that you've engaged in any kind of work since onset that might be at SGA, substantial gainful activity level. So I'd say you're about 95% there. Is it possible that some another level reviews it and says, no, we're not going to approve Don? They could, but I think it's pretty unlikely. So again, you're in the home stretch. You're about 95% there, in my opinion. Prepper Joe says there is a medical facility that Social Security sends disabled people to see when going through their CDR. And again, this is a consultative evaluation for a continuing disability review. Claimants are complaining it's a scam. The doctors are fake. They consistently deny cases. Thoughts, and it goes on to say, I've read horrible reviews about the facility, and claimants are considering hiring lawyers and going to Social Security, up to Social Security in that facility. This is the problem of consultative evaluations, where they use doctors who are, again, these industrial clinic doctors whose main livelihood arises from working with insurance companies to deny claims. You can certainly argue, if let's say you go to that doctor and the report comes back, against you, you could certainly raise the issue in your appeal that this facility is bogus. It's known for all these issues, for fake reports and things like that. Obviously, at some point, somebody might look at this as a class action, that this facility, is wrongfully denying people. That's a whole different ball game. But I would certainly tell you to take notes as to what happened. If you have your own records, you obviously want to make sure that those are part of the record when you, appeal, if they move to terminate you. But, there's not, and I guess in theory, you could report this facility to Social Security's Office of Inspector General, although I believe that right now that position is empty, at least for the time being. I think you might also even go to the press. This is one of these situations where if you're aware of 15 or 20 people that have had the same report from this facility, get those reports together, get these people together and call your local consumer advocate on your TV station, local TV station, and have them reach out to Social Security on your behalf. That type of negative publicity sometimes gets results. So, you don't have a lot of options other than to go, but yeah, you can certainly prepare for challenging it, both with other medical records, with, arguments that the facility has a reputation for being unfair. Have other people, if you have 15 reports that say the same thing, that would be grounds for that. And again, that may be something that, you could have a lawyer, or somebody appear at a hearing and basically talk about, even the news person, or even have somebody who's, analyzing all these reports, to come and say that this should not be given any weight because they're all the same and there's 15 of them, and it appears that this facility is not doing a thorough job of properly developing the record. So got to get a little creative. I would certainly talk to your lawyer about it, but this is the sort of thing that as a lawyer I would tell you, be as prepared as you possibly can, because this is the sort of thing where you may have to go through many hoops to finally get them to not look at it. And I know in the past there have been some instances where people have filed class action suits against Social Security, against vendors or whatever, for this type of nonsense. And, eventually you may get relief, but that could be 7, 8, 10 years down the road. In the meantime, you want to try to keep your benefits. Steve D. He is age 64. He injured in a motor vehicle accident, workers' comp, as of November of 2023, applied for SSDI in September of 24, approved in January of 25, 86 working days start to finish. The attorney handled all submissions. I'm totally amazed it went so well. That's great. That's awesome. I mean, the fact that you're 64 makes a big difference for a couple of reasons. One is that if it's physical, the grid rules apply. Not only do the grid rules apply, but there's something called a POMS regulation, which says that, if Social Security's got to show that you could return to past work, they've got to prove over age 55, if you're limited to even light work, at over age 60, rather, that any job would be essentially the same job as you came from, which means it's almost impossible to prove you could do past relevant work. Any skills that would transfer aren't going to be there, so you probably would grid out. I think also the fact that you are close to retirement age, it's not really a drain on the trust fund. Now, I do wonder whether the workers' comp is going to offset your benefits. That's something to look at, but it's certainly a positive sign to see a person clearly deserving get approved. And again, this goes back to that emergency message. We're going to see people over age 50 and especially over 55 get more early approvals. And this is probably not something that was part of this emergency message, but you can see that's the goal of Social Security, is to approve the straightforward, easy cases first. And yours obviously kind of fit in that category, even though not in a not as part of this emergency message. And he says he was awarded at step 3, which again, that whole step 1, 2, and 3 on the online status doesn't mean anything in my opinion. Luke Rogers. Good to see you. Good to see you too, Luke. Will the SSDI approval rates go down from the new presidential administration? Please explain and advise. We don't know yet. Social Security judges are independent, and believe it or not, my experience has been over the years that if you have an administration hostile to claimants, judges tend to sort of take it the other direction, and they tend to approve more cases. We sometimes, believe it or not, see a downturn in approvals when you have administrations that seem more sympathetic, and an upturn when you have administrations that seem less sympathetic. Maybe it's the ALJs, giving it to the man. I don't know. We'll see. Now, again, Social Security is a part of the executive branch. There may be policies that come down that are anti-claimant with the goal of reducing approvals. We'll be on that. But right now, we've not heard of anything to that effect. So I'm hopeful that Social Security judges will retain their independence. Again, this emergency message, sort of says to me that they're trying to get the, straightforward cases approved more quickly, and then, deny the other ones, and it'll work through this long system where it's going to take 2.5 years, and then you get in front of a judge, and then, we'll see what happens. So I think they're going to try to, eliminate these easy cases at the outset. They're not going to give Social Security more money to deal with the ones being processed the normal way. And then when we get to a hearing, we'll see what the judges do. But I suspect that the biggest thing we will see is the long delays for a lot of cases. The ones that are not, the straightforward ones are probably going to get longer, if I had to guess. Trish says, hello, Jonathan, everyone. Hello, Trish. Hope you are doing well. How will the Chevron case affect Social Security? So far, nothing. That's basically a federal court case that talks about, it's basically having to do with agency law and whether an agency can promulgate its own rules or does Congress have to do it. And it was very narrowly, issued this case, Supreme Court case, to focus on one particular agency. And of course, a lot of people say, well, if it applies to, this agency having to do with fishing, I think is what it had to do with, then it would apply to every other agency. So far, we have not seen anything. Now, I suspect that there may be some cases working their way through the system where people are arguing that, the Chevron logic applies to other agencies. What my guess will be is that Congress will just, ratify a lot of stuff that Social Security has done. And, it'll be no harm, no foul, but who knows? But I suspect those cases are winding their way through Congress right now, or through the courts right now, but we have not seen anything or any indication that the Chevron doctrine is going to have any major change with Social Security. But again, who knows? Sometimes you wake up and all of a sudden this case came down, another Supreme Court decision says it applies to every agency, then they all have to scramble. There was every few years there's a case. Look, there's one right now where Social Security had this ruling. It talked about the Dictionary of Occupational Titles, and because it's really outdated, and if you know what I'm talking about, is Social Security, it has to prove that there are jobs that exist in the economy, in many cases, in step 5 of the sequential process, that you could do. And so, for many, many years, as long as I've been doing this, Social Security has relied on something called the Dictionary of Occupational Titles, which is the Department of Labor publication. The problem is the DOT was last updated in 1990. Well, we're in 2025. And, something that is that old, 25, 35, in some of these cases, even older, a job that was described 30 years ago does not exist the way it does now. An example I always give would be, photocopy, what do they call it? Photocopy attendant. Back in the day, 1990, 1995, you'd walk up to a photocopy machine, slap a piece of paper on the glass, hit a button, and make a copy. Well, and I was, you could pretty much, if you had a, 5th grade education, you could do that. It didn't require much training, skills, and even if you had a mild to moderate headache, you could do it. Well, now, every copy machine in an office is a high-speed scanner. So if you're making a copy, you've got to be able to, put it in the machine, find the right destination, scan it to a particular destination, then download it from an email or from a box, internal box on your scanner to somebody's folder. There's, 5, 6, 7 steps, and it goes from being an unskilled job to a skilled job. But if you look at the DOT, it's an unskilled job. And there are many examples like that. So over the years, Social Security has released, again, some of these times emergency messages or rulings that say that certain jobs do not exist, the way they did under the DOT. For years, there was a job called surveillance system monitor that, you're looking at monitors, looking at somebody breaking into a used car dealer. And that was used to deny cases for years and years. Lo and behold, a couple of years ago, Social Security comes out and says, that job does not exist in significant numbers. Can't use it anymore. So they've done that a few times. Well, more recently what they did, they came out with a ruling that said the DOT is so inherently flawed and so outdated that we cannot just rely on that, and that at hearings, judges have to ask vocational witnesses the sources of the numbers and the jobs they come up with. And so what we're finding now is that judges ask at the end of hearings a series of 5 or 6 questions to vocational witnesses, asking them, where they got their data from. And it's just all kind of rote. And, you can challenge this because there are many situations where the DOT does not line up with some of the other resources. There may be 5 or 6 jobs in, this other resource that was, one job in the DOT, so the numbers get skewed. And there are attorneys I know who basically in every single case will go after the vocational witness by saying that, the resources they use, there's computer programs, these are all flawed, and that we really don't know how many jobs exist in the economy for certain or for any job title. My sense is that judges are going to be reluctant to just throw out everything, because now there is no way to basically say that that there are jobs this person can do. And so unless Social Security is going to approve every single case, which they obviously are not going to do, the appeals courts are going to find a way to allow some of these other resources, imperfect as they are, to pass muster. But again, there are attorneys I know who are, getting denials on the basis of vocational testimony. They're going to use that to appeal it to circuit courts and maybe to the Supreme Court. And we'll see. Maybe the circuit courts, the Supreme Court will come back with some other conclusion about how Social Security has got to evaluate jobs. So the point is that, there's always things going on behind the scenes. And, we may wake up one day and find out that all of the resources that Social Security has been using to determine job numbers and job, availability are flawed, and so flawed that we can't rely on them at all. And, they may say, we got to do these hearings all over again. They may come up with another, methodology for estimating jobs. But right now, there seems to be a consensus amongst judges to ask certain questions in a certain way that satisfy them, and that satisfy, the people that are over them, the appeals council and district court, that these job estimate numbers are accurate. But stay tuned, because that very well could change. But again, the Chevron case is again another example of a federal court case that, could change the way things are done. Realize that agencies like Social Security, are going to be reluctant, or that courts are going to be reluctant, let me put it this way, courts are going to be reluctant to throw out all of an agency's policies and procedures, and basically put everything into chaos, because, yes, maybe, thousands of people get a rehearing on, with under the new protocol, but imagine the delays that's going to cause. So is it better to throw the whole thing out and start over again, or is it better to figure out a way to kind of jury, I think it's called, what's the term, jury rig maybe that's the wrong term, but to create some sort of a rickety structure to make it all work. So I've talked enough about that. You get the picture, is that things do change periodically, and we may find some interesting changes down the road. Treston Jordan Miller says, hello everyone. Hello, Treston. Jenny Jo says, good evening all. Vince, my client Vince, how you doing, Vince, says hello. Good to see you here. MT is a 43-year-old male. He has severe scoliosis, which is a curvature of the spine, and has had 3 back surgeries. Now of a herniated disc and spondylitis, which I guess you mean the bones are fusing kind of naturally. Diabetes, diabetic neuropathy, peripheral neuropathy, legs and hands stay numb. I think the medical evidence is quite strong based on what you're describing. And again, you'd want to really look at the medical evidence, but based on that, you've got a lot of stuff going on. And I think it's reasonable to say that's going to cause some significant impairment. You are 43, which means that you've got to prove there are no jobs you could do. This, if you were 53 or 63 or 58, I think your case is really, really strong. Being 43, you've got to show there are no jobs you could do. I have won scoliosis cases for people in their 20s, because you realize you're looking at this, you're saying, what kind of job, this person, how long could he sit? How long could he stand? And, if you can show that you would not be able to get through an 8-hour day without multiple breaks, you're likely to miss 2 or 3 days of work per month. I think, I think you've got a pretty good argument. Now, what I would do is I would reach out to your doctors and see if they will complete a functional capacity form for you, or you might talk to your doctors about sending you to a physical therapist for a formal functional capacity evaluation. It may take a day or two to go through it all. That gives you a formal assessment about your capacity. If it comes back less than sedentary, then you've got a really strong case. So my point is, you've got a really strong case based on the medical. Your age is the factor, and realize there are a percentage of judges out there that are really reluctant to approve anybody under age 50. You would be probably one of the exceptions. but you're going to have to make sure you've got really, really strong evidence. I always like to say that when I see a judge with a 41% approval rate or 35% approval rate, that the ones they're approving generally are, 95% of those are going to be people over age 50 or 55, probably most of them over 55, and maybe 5% are younger people with something really severe. And MT, this kind of looks like it might be one of those 5%. So I'm just making up the percentages, but I think you get my drift. This may be one of those, rare cases, but, at the risk of getting in front of a judge who just knee jerk says, I'm not approving anybody under age 50, you want to have your ducks in a row. But I think that based on what you're describing, if you can get some functional limitations out of your doctors and or a formal functional capacity evaluation, I think that you've got a pretty good shot at winning. Blue Z. I have a phone hearing. I have very bad anxiety and you stutter. Also have I'm not sure what that, I'm not sure what that word is. I can't pronounce it. Crying outbursts. Will the judge understand if you have trouble speaking and answering? I would say this is a situation where your attorney ought to do a pre-hearing brief that explains these particular issues and that, spells out the argument very, very clearly. I had a hearing this morning, for example, where the judge started out by saying, counsel, I just want you to know I have a really busy docket today. I've got a lot of hearings and we're going to need to move through this really, really quickly. I'm not a big fan of that, by the way, because if you waited 2 years for your hearing, I think you ought to be able to have a fair hearing and you shouldn't be rushed through by a judge, but you don't want to piss off a judge. So I'm like, okay. Now I had written a 4-page brief, which really spelled it all out. And so, she said, you have an opening. I'm like, no, look, I've done a brief. Please take a look. I would defer to my brief. I'm obviously very polite. But when someone asked my questions, I really just kind of honed in on what is your capacity for, to ask him about his work attempts. I asked, after onset, I asked him about, his medical issues and kind of the physical specific limitations, sitting, standing, walking, kneeling, crouching, crawling, all that kind of stuff. And he had neck and he had back and he had knee and he had, some other things going on. So we kind of zoomed through it. And, the judge had no questions, or like 1 or 2 questions, and went right to the VE, asked some questions, and then closed the hearing. I don't know, this judge has a, lower than I would like approval rate, but, I tried to meet her, request to make it quick. I felt very comfortable doing that because my brief spelled it all out. And I think that, if the medical evidence is there, what the claimant has to say is, not as really important as what the medical evidence says. So again, if you have a lawyer and there's evidence of bad anxiety and of stuttering and crying and things like that, and your lawyer can point to that and can basically say, Your Honor, I want you to be aware that my client, it's very likely because she's going to be very anxious during this hearing that she may burst into tears or she may have terrible time stuttering. I think that would be a big help, and I think judges would appreciate knowing that. And I think that, again, you ought to practice with your lawyer, just getting out, having knowing the questions are going to be asked and practicing the answers, even kind of sketching out those answers, not necessarily writing them out, but just having bullet points so that when your attorney says, how often do you have episodes of stuttering, you're not thinking about it for the first time at the hearing. The answer is, at least 3 or 4 times a day, or if I'm put under pressure, and the anxiety until it resolves itself, it's going to continue to happen. It seems to be a ongoing thing with the anxiety. Anxiety can be triggered by high stress. It can be triggered by temperature, very hot. It can be temperature by family pressure, any number of things like that. But I think the more the questions that are coming, the more likely you're going to be able to get the answers out, especially if you practice those and if it's already set out in the pre-hearing brief. So I wish you the best of luck with that, and hopefully you get a judge who's pleasant and friendly and is not going to try to make you even more anxious than you already are. But again, if you let them know ahead of time, that's really, really good. And MT, who's our person with scoliosis, it's been 1 year and 5 months, are still reviewing records. My attorney says he got an update that says next step, send them, yes, right. So again, you've got the severe scoliosis. you've had back surgeries, they're going to send you to one of their doctors. And, in my experience, if you've had surgeries, you've got, radiological evidence of severe scoliosis, you've got, all these other, diabetes, this might be a situation where you bring some records. It's going to be kind of hard for even the most jaded, industrial clinic doctor to say there's nothing wrong with you. And look, if the doctor comes back and says, you could do light work or sedentary work reliably, you've got a lot of other evidence to say you can't. And I think that most judges are not going to give it a whole lot of weight. But, again, this is about being prepared. And I think if you've got a lot of evidence that supports you and the CE doctor is aware of that, it's going to be harder for that person to, to write a report that says there's really there's something you could do when in fact there really isn't. And he'll look like a fool if he does say that. Crystal says, I had my hearing on January 14th. When can I expect to hear something? Does it normally take that long? Is it a good sign? There is no correlation between how long it takes and the decision. What's happened after the decision is the judge sends it to a decision writer. This is a person who is not at the hearing, is in a cubicle someplace, up in Maryland or whatever. I had a former employee of mine who worked as a writer for a period of time. He said, imagine a, office, building full of people writing decisions. And it's just a matter of how busy they are. I have cases from November that I've not gotten decisions on. I've also had cases that I tried in January I've already got decisions on. So it just kind of depends on the particular hearing office and how fast they can get it out. But I would tell you, you should hopefully hear something by mid to late February. But you just don't know. It could be longer than that. It could be tomorrow. We just don't know. But there's no correlation between how much time it takes and good or bad news. Violetta says, hello. What is the situation if somebody has neurological pain? I would say this, I think first of all, it's going to depend on how old you are. Is there a organic source to the pain? Do they know why it is there, or is it some sort of an idiopathic pain? Neurological pain, very, very hard to treat. They use things like gabapentin or Neurontin is another brand name for it, but that has really severe side effects. So I think it's a matter of proving that the level of neurological pain is severe enough to interfere with focus, attention, and concentration. Your doctors may want to do something called an EMG, which is like a nerve conduction study test that might, prove that it exists and how severe it is. But again, this is going to all come down to the overall medical scenario of your case. Again, how old you are and how this affects you in a work environment. You don't win, I know I sound like a broken record, you don't win a disability case on a diagnosis. So you've got neurological pain or neuropathy, but that doesn't mean you win. It's how severe is it? Is it treatable? Is it constant? How does it affect you on a day-to-day basis? If you're over 55, let's say, and it affects your feet, then you maybe have a grid rule argument because you can't stand and walk. If you're over 50, maybe you have a sedentary grid rule argument. If you're 35 years old, even with neuropathy or neurological pain, it's going to be a real uphill battle. So, it's just going to depend on, the severity of the condition, how long it lasts, is it treatable, your age, all the factors in your case. Tara Upshaw, how are you? Tara, one of my clients, how are you doing? Hope you're doing well. Blue Z, okay, I think we've already answered that question. Jeff Brown says, good evening, everybody. And Jeff, how are you doing? Mr. Ginsberg says, Kelly Brickman, we're so encouraged. You were, okay, so you were, I think I referred you to Lisa Palmer. Lisa's great. So I think that, what you must be talking about is the attorney's fees apart. And basically what most of us use, Lisa I believe does as well, is SSA Form 1693. And any attorney who wants to charge a fee has to be approved by Social Security. And Form 1693, or a fee agreement that's roughly equivalent to that, says that the attorney can charge, on a fee agreement basis. That's one way to get paid. No more than 25% of past due or the lump sum benefit with a cap of $9,200. You can also do something called a fee petition, which nobody wants to do because they take forever. So if if you talked to Lisa and she sent you a fee contract and is taking your case, that's a great sign. The nice thing about these no fee unless you win contracts is just what I said, no fee unless you win, which means that, you have an attorney working on your case for 2 years, helps with initial, helps with recon, helps at a hearing, helps with the forms, answers your questions, and you don't pay a dime unless you win. And, unfortunately, there are situations where, you work in a case, as speaking as the attorney, I work in a case for 2 years, I get a bad judge, the case didn't develop the way I wanted, and I don't get a favorable decision. And so I've had, 2 years of work, I've paid my staff, kept the file active in my office, I don't see a dime out of it. So that's the risk we take. Obviously, that means that attorneys, like me, and again, everybody that I know that does this uses a contingency fee contract. You're going to be selective about what you take. That's why if you're 25 years old with a bulging disc, you're going to have a hard time finding a lawyer because the odds of winning that case are just pretty slim. So, most lawyers aren't going to take it since we only get paid if we win. So the fact that a lawyer takes your case says that you have a lawyer who's willing to take the risk that you have a winning case and work on it for 2 or 3 years in that hope that they're going to get paid down the road in 2 or 3 years. So yeah, that's a good sign. Lisa's great. I keep asking her to come on, and one of these days I'm going to get her on, just like I have had with Jeff Herman. I've had with Stephanie Joy. I've had a couple other people. So we're going to try to get more people on. But Lisa is one of the people I want to get on because she's real sharp. She does VA work, and she's also written several books, pamphlets about disability. And I'm sure that she's got some great insight that we can all learn from. Okay, David says, I received my disability. I'm trying to get back to a part-time work. How much is the best salary you can make? Well, there's 2 ways to answer that question, David. One is that you have something called a trial work period. And let me get you the numbers here so you know what I'm talking about. And that is for up to 9 months in any 5-year period of time after your date of approval. You can go to work, you can earn as much as you want. And you have up to 9 months of doing that. And as long as your earnings, you use up earnings, if you are, let me see here, I think it is $1,160. So if you went to work tomorrow, you could earn up to once you earn $1,160 in a month, you use up one of your trial work period months. You have 9 of them. So you can earn $1 million a month for 9 months, and it wouldn't affect your benefits. After that, after you've used up your trial work period months, then you don't get terminated at that point. But then Social Security says, well, are you earning over SGA, or substantial gainful activity, which in 2025 is $1,620 per month. So after you've used up your trial work period months, if you start earning more than $1,620 gross in a month, and that's when you receive the money, then you go into overpay status. So the answer to your question is earn as much as you want, as much as you can, for up to 9 months in any 5-year period of time. It rolls off, months start rolling off once you hit 5 years. But if you use them all up, then be very aware of that 1,620 SGA figure, because if you exceed that, you get into overpay status. So, in theory, if you were to go to work and you were to earn $1,000 a month, you're not going to trigger a trial work period. You could do that indefinitely. Or if you were to earn $1,500 a month, you use up your trial work periods, but you would be under SGA, so you could do that indefinitely. I always tell people, earn as much as you can earn because you want to try to go back to work, but don't get into overpay status. One of the problems here is that there's no online, place where you can track where you are in this 5-year cycle for the trial work period, or have you used up, or have you gone over SGA? So you've got to keep your own records, and that can be very difficult to do. because again, you may not realize that you've used up your trial work period months, and all of a sudden you go over SGA 3 or 4 months. Now you're in overpay status. A, it could trigger a continuing disability review, and B, you may get a letter from Social Security saying, we overpaid you about $4,500. Here's an envelope, send it back. So you want to be real careful about this. I think the big picture here is that, I realize Social Security has to track, they want to both encourage people to try to go back to work, but also not, give people a blank check, as it were, to earn as much as they can and still get disability benefits. The problem is it's so difficult to track it. There's no real-time way to do it. And it's so easy to get into overpay status that many people decide it's not worth the hassle and they don't go back to work. So it defeats the purpose of encouraging people to go back to work. I think if there was some online utility to track your earnings in real time, so you knew, different story, but it doesn't exist, so you got to just track it yourself. But that's the answer to that. So you can do the trial work period, which again, 9 months in any 5-year period of time, that is $1,160 a month. Once you've used those up, you need to be aware that $1,620. These are all gross figures before taxes, and the earnings are based on the month you receive the check, not the month you did the work. Mandy Music. Morgan & Morgan of Tampa and phone interview with the judge, lawyers for SSDI. Still think I was done wrong. I don't speak about other attorneys because, sometimes you have an attorney who does a perfectly good job and you have a judge that wasn't reasonable or the medical evidence was not strong. Let me tell you, I get people that send me unfavorable decisions, several times a month, and, they are mad as can be that the case got denied, the judge was wrong, and blah, blah, blah. And sometimes I'll get the audio, I'll listen to it, and, the person's recollection of what happened is not what actually happened, or, I'm looking at a decision and the person said, well, the judge made this mistake. I was looking at one today. The judge said I was 48 years old. I'm in fact 55. Well, you were 48 at onset, so the judge was not wrong in that regard. Again, I haven't finished this review, maybe other problems, but things that this person was upset because the judge says I'd done these 5 jobs in the past. Well, that was the vocational expert answering jobs and hypotheticals of what you might be able to do, not what you did. So sometimes it's just not understanding the just the process of a hearing and what goes on. It happens really, really quickly. And if you're not familiar with that process, it can seem like you're being treated wrong. And in fact, everything is being done the way it's supposed to be done. So I can't comment about that. I'm not going to speak ill of another attorney because I don't know anything about your case. And again, sometimes it's just a matter of just drawing a judge that's unreasonable. Okay, Susie B says, I just received a favorable decision. Great. SSA paperwork says my 2 adult profoundly disabled children might be eligible under the disabled adult child. They get SSI as medically disabled adult. If they go through the 2-year process, I don't think so. I think that, if you've already been proven disabled as an adult for SSI, you go through the disabled adult child. Basically, it says that you became disabled before age 22, I believe. You've already been deemed disabled. I think it's just a matter of applying, and hopefully they put the pieces together. Now that you're receiving disability benefits, your children become eligible for disabled adult child. It does not have the income and resource limits that SSI would have, and obviously if it's more money, or at least up until a certain point more money, that's a good thing. So I think I would go ahead and apply for that, and I don't think that you're going to have to wait 2 years. I think it's going to be pretty quick. All right, Dogs Are Me 100. Easy for me to say. How helpful are failed work attempts for younger people? I think for everybody, a failed work attempt can be compelling evidence because what it is showing is that you tried to work. And believe it or not, judges are looking at you, and to a lesser extent, adjudicators. Is this person invested in the idea of being disabled? Do they want to return to work? And, a judge really appreciates somebody who's fighting this. And I always tell my clients, when you go to a hearing, You want to present yourself as a fighter, somebody who the last thing in the world you want is to be sitting here asking some judge for disability benefits. You want to basically say, I am fighting this. I don't want to be like this. I'm only here out of necessity. And if I can get better, I'm going back to work. They appreciate that because, again, they're under pressure to, only approve deserving claimants, number one, and number two, that there's this looming problem of Social Security running out of money. And so they're aware of that. And they're under pressure. So I think that if you have failed work attempts, you're already demonstrating to Social Security you're trying to work despite your medical issues. And so if you're willing to do that before you get approved, you're probably willing to do that after. So I think it's a really important factor, especially for younger people because, it's harder to win when you're younger. But for anybody, I think I failed, 4 or 5 failed work attempts. When I'm doing a brief, I'm going to put, this person has tried to work. And here's what happened. My client today, he has really bad numbness and tingling in his arms and hands because of severe cervical issues and herniated discs and so forth. He got a job. He'd been a manager, a restaurant manager. He got a job as a server. He kept dropping plates and glasses because he can't hold on to anything. And he told the judge, he goes, look, I wanted to find a job I could do. I know the restaurant industry. I got a job easily as a server. The problem is I was breaking all their glasses and their plates. And so they had to let me go. That was compelling. And I think that sort of thing is very, very useful if it does exist in your case. And you want to document that as much as you possibly can. All right, Christina, who is, I believe, in Bakersfield, California. Every week we ask Christina if the fires are near her. And every week she tells us no. So hopefully that's still the case. But hello, Christina. Good to see you. Let me change the... I'll just put this one on here. So if you are enjoying this, please do leave me a review. That would be very, very helpful. Here's how to do it. I've had some nice reviews. And by the way, if you do leave a review, I would appreciate if you would write a couple of things. I've had people leave 5-star reviews, which is great, but they don't say anything. Just something as simple as, I felt the live stream was very helpful. The videos gave me a clear idea of what I needed to prove, or whatever you want to say, but just give me a sentence or two. That would be most appreciated. Okay, they had my medical records. I report everything. Okay, this is Mandy Music. I'm not sure, Mandy. Okay, that's the one who had another law firm, and the interview with the judge is actually it's a hearing, not a phone interview. People call it a meeting or an interview. It's a hearing, administrative law judge hearing. So what you're saying is that you had all of your medical records and you gave everything to your lawyer, which means the record is complete. That is a good thing. Hopefully you'll get a good result. Teresa Kempton. SSD contact me today. We'll make a decision on my past claim. I'm not sure what that means, but that's good. If they're going to make a decision and they're telling you it's in progress, that's good. Silver Monster. You said in the past that ALJ would try to negotiate the onset date when issuing a favorable decision. If you could approve your initial and recon, will the adjudicator do the same? No, generally not. Every blue moon, I get a phone call from an adjudicator saying, I'll approve this, but I can only use this onset date. Would your client go for it? That is exceedingly rare. Once every few years that happens. Generally speaking, they just do it. I got one literally right before I went on. One of my assistants sent me an email saying, we just got an approval of a case, but they changed the onset date by 2 years. What do you want to do? And of course, I'm going to look at it, and we're going to talk to the client and make a decision about whether to do it. I have another client I talked to today, a gentleman, and we are going to appeal it. They changed the onset date. They cut him up by 2.5 years. It's ridiculous. I think we've got a winning argument. We're going to appeal that. We're going to appeal essentially it's a partially favorable decision, which puts the whole thing back into play. But his medical is so strong that I feel, that the risk is acceptable. But again, he had to make that decision. Like It Is. Hey, you doing, Like It Is? Hit the like button. Like It Is says hit the like button. So I will go with that. Absolutely. Thank you. All right. Doris, I'm 59. My past work was as a hand packager. They're doing a CDR for 7 years. Should I apply for the grid rule? Absolutely. Absolutely. I think that you're 59. So when they do a CDR, and realize that, the CDR process starts with you give you a form. then they make a decision about that they're going to try to terminate you, and you can appeal that. So I don't know where you are in the process, but yes, anywhere in the process, if you meet a grid rule, and 202.04 is in the light grid category, and let's take a look at that just to make sure you got the right one. 202.04 says you're a high school grad or more, but does not provide for direct entry into skilled work, and your past work is unskilled or none. So if a hand packager is an unskilled job, then 202.04 is correct. Yeah, I think absolutely saying, at 59, you're doing a review. I meet the grid rule at 202.04. And I would keep saying that. And I think that's exactly what you want to do. I think it's very unlikely they're going to move to terminate you, or that you would be, in fact, terminated. Remember, though, if they do move to terminate you, you have 10 days to ask them to continue benefits while you appeal. The problem there, of course, is if you have them continue benefits, then there'll be no past due benefits. You can't find a lawyer, on a contingency, because there's no money for the contingency. If you choose to have benefits stop while you appeal, there'll be past due benefits to pay a lawyer, but you'll have no money coming in. So it's a really, really tough choice for those who are being reviewed if you get to the point where they're moving to terminate you. So hopefully you're not in that point yet, where they're just talking about it and you want to kind of head it off to the past by referencing the grid rule, which I think is very, very smart of you. And hopefully this will not be a problem for you, Doris. Christina says, as she always does, please do not forget to like, share, comment, and subscribe. Absolutely love comments, love to answer questions, and I do appreciate the likes and so forth. And I'll tell you what I'm doing now, by the way, you'll start to see this, is I'm taking little cuts of the live stream where I'm answering questions and making those videos. So you may see some of these questions appear on 7 or 8 minute videos that are going to be part of the YouTube channel. It just gives me more content, and I'm answering questions kind of off the cuff, which is a little different angle, a little different vibe. I hope you like that. And again, if you do have a question you want to get answered, I'm more than happy to answer that. You may find it on the YouTube channel. And to that end, if you don't want your name out there, use just when your YouTube channel, change the name so it's not your full name. Just be like it is, or be whatever, your first name only, or some pen name. And that way, you're not, your privacy is not involved, because obviously these, all these questions on the live stream are being, recorded. It's going to be on the YouTube channel, and I think on the Facebook page, forever basically. So if you don't want your name in there, use a fake name. Robert Long, let's see, I'm not sure, II or LL was done for hypertension, double hip joint replacement. Counselor at vocational rehab took me outside and said, just go for disability, be done with it. Approved in weeks. Okay, so Robert appears to be 63, which again makes life a lot easier. He had a double hip replacement, has significant, I'm sure, limitations. The voc rehab person said, just apply for disability. There's no job I can find for you. You're likely to win, and he did win. And again, this is the kind of case that the emergency message is designed to capture a person that clearly should be approved early, and obviously he was. And congratulations, Robert. Teresa says, I've tried to work different jobs and have mental disabilities at 51. So again, Teresa, you're the one who said they contacted you, will make a decision. I think the fact that you tried to work jobs is a good thing. It shows you're motivated to work. These are considered, if they lasted less than 6 months, unsuccessful work attempts, or UWAs in Social Security terminology. That can be very helpful. It shows you're a credible, believable person, and that you're motivated to work, and those things all work in your favor. So I hope that this works in your favor. You get an approval. Lulu says, after 4 months, I need to leave the country for 3 weeks. What forms should I expecting to come? Would not like to go to the forms start coming in my mail. Well, I would say this. If you have to leave the country, just number one, be prepared to explain why you had to leave the country. I've had it come up at hearings. I had to visit a parent who was sick. I had, my daughter decided to take me on her birthday, and she wanted me to come, and I just basically stayed in a hotel. Just be prepared to explain what you did. I would almost tell you, if you're having somebody get your mail, have that person, if they see something from Social Security, open it up and scan it to you, and you can answer it from wherever you are. I mean, you don't need to be in your house to do it. Again, everything's now pretty virtual. You can even do many of these forms online. So, for example, if you get a activities of daily living form or a disability report, you can probably just put that form in, put the form number in onto Google, and you can actually see, you can type the answers in. So if you have a phone or a key, an iPad or a computer, you could probably answer the forms that way and then have it printed out to PDF and send it to somebody and have them submit it for you. If you have an attorney, they could do it. So I would just say, don't, if you're going to be out of town, out of the country for 3 weeks, normally they give you a little time to answer the forms, but I would probably tell you, if it was me, I would have my neighbor or friend check my mail, let me know if one of the forms came in, and then just do it anyway. And even if you're out of town, just get the form in, or if worse comes to worse, you just can't do it. You could, if you get the form, you can write Social Security and say, I had a family emergency, I'm out of the country, please give me until XYZ date to get this form back. And they normally will do that. So, again, if you have an attorney, the attorney can run interference, the attorney would get a copy of the form, but that's what I would do. I just would, try to make arrangements to get the form completed where you are, assuming you'll have access to a computer or tablet or even a phone. Okay. Timothy Colson, if a person is still pending since 2018, that's way too long. If you've been since 2018, I mean, that's 7 years. So, I would be shocked if they haven't just closed your case out. That just makes no sense at all. I think that you need to really kind of find out what's going on. If you can't get anything from Social Security, contact your U.S. Senator and see if they can, find out something for you. But there is just no way I can imagine that an active disability case has been pending since 2018 and you're not getting any news on that. That's beyond what Social Security does. So something is really, really wrong. Prepper Joe says, thank you for answering my question. My pleasure, Prepper Joe. Jeff Brown, if I apply before 55, like 53 and a half, by the time I get to the judge, I'll turn 55. Will they use my younger to deny me or choose the 55? Well, again, what would happen is the judge would look at your onset date as of your 53 and a half, and it'll say in the decision that the claimant changed age categories during the course of this case. And so, what I've seen judges do is they'll approve you as of your 55th birthday, which means they'll cut out a lot of past due benefits. Not every time, but that's something that could happen. So I would tell you, if you're 53 and a half, and you can continue to work for until you're close to 55, do so, because again, there's a decent chance they'd cut you out anyway. You might as well get paid working. You might as well get more earnings credits in there. And then when you're 55, now you have the light grid rules available to you. So if at all possible, I would tell you just to keep working, because at the end of the day, you may not see any money for that time period from 53 and a half to 55. Not saying absolutely not, but that is a very, very real risk. Is it true, T-Cash asks, that more than half of government employees are working from home even before COVID? Not before COVID. COVID sort of changed everything, and that the union negotiated a contract where Social Security employees could work, a lot of them at home. First of all, Social Security wanted them at home because of not avoiding infections, but after that, they really liked it working at home. They don't want to come back in. And of course, all the hearings are now virtual, which is good for me because I can represent people all over the country. And it's really, really easy to try cases. I'm literally in a t-shirt and shorts trying cases. And what's better than that? I mean, as opposed to driving 2 hours to get to a hearing office, for 45 minutes and turning around and coming back. And I've used up, 5 hours out of my day for one hearing, whereas I can do 3 hearings, in 10 o'clock, 1 o'clock, and 3 o'clock, much more efficient. So I think that, the government right now, the executive branch is trying to get more people back to work in office. Whether they're successful or to that, I don't know, but I still think we're going to have ongoing virtual hearings. I certainly hope so, because if not, it would make my practice impractical. I couldn't do it the way I'm doing it. Jen, my paralegal in Nebraska, is tuned in. Jen had a very, very busy week, and I'm glad to see her here. Hey, Jen. A hidden SSI approved December 24, waiting a hearing date for SSDI. So this is not uncommon. You have a joint filing. They approve SSI early. Then you still have a disability hearing. 56 years old, state rep called to see if the date had been set, and call when it does. State of Virginia. Yeah, I think that if you got approved for SSI kind of presumptively, that's a good sign, because obviously somebody felt like you were disabled. It's, I think likely you're going to approve for SSDI. And of course, what that means is the SSI will be offset. And if you have past due benefits, they'll reduce your past due benefits by the SSI you got. But yeah, I think that's all good, all good. Richard Otts. How difficult is it for younger adults to qualify for SSDI? 36, veteran, failed back surgery, multiple MRIs showing stenosis and degeneration, taking oxy daily. Richard, this same kind of issue, or I won't answer the question. Somebody asked this before, and that is that it's always difficult to win under age 50. At 36, you need, a very, very high level of persuasive evidence. Failed back surgery, multiple MRIs showing stenosis, disc degeneration, you've been prescribed oxy. That sounds pretty severe. Again, you still have to prove you can't do anything. And as I told the other person, I would see if your doctor will complete a functional capacity evaluation. I would tell you, if you can afford it, get a formal functional evaluation with a physical therapist, and you've got a decent shot at it. But, you are going to run up against adjudicators and judges who just, knee jerk, you're under 50, you're in your 30s. I'm not approving you unless you're in your deathbed. So you have to get past that. That's why it's more difficult. But, again, you're an oxy, which is, pretty heavy duty stuff. You've got objective evidence of significant back problems. You had surgery, it didn't work. Those things all would work, I believe, in your favor. SGA 16, that's correct. SGA, did I say it was different? I think that's what it is. It's 1620 in 2025. It was 1550 in 2024. So if you are over SGA and you're receiving benefits, you risk going into overpay status if you've used up your trial work period months. Okay, let me put back on this free case of Al form here. Okay. And we have Corel Katana. I have a medical exam tomorrow. So again, you just want to tell the truth, but don't be surprised if it's a physical medical exam. It doesn't really help you very much. That's just, the way it goes. And hopefully you've got other evidence. Steve D says workers' comp offset. But yeah, so, in his situation, I'm not going to kind of go into this too much, but the workers' comp offset, it depends on the percentage of your previous pay and so forth. But there'll be a workers' if you're getting ongoing workers' comp and get Social Security, there's a good chance that a lot of your Social Security will be offset. In some cases, not all of it, but a lot of it would be. And that's what Steve is saying. He's the one who had workers' comp and got approved very quickly for disability, which is a nice thing. Jenny Joe says hello to Jen. Steve says, my wife and I are gold mine of information. Well, I appreciate that very much. I'm actually the video guy, and Jody's my wife, and so I get her to do videos, and we come up with the topics, and she doesn't really like to be on camera that much, but I get her to do it. The other day we did a bunch of video shorts. That's kind of the new thing. And I just recorded a bunch of them today. And video shorts are basically these 1 minute long videos that talk about a couple of points, but we both believe that the more we can educate our client base, the better. And, again, I really like the video format because it allows me to just talk to people kind of like I'm talking to a person one-on-one. I think Jody is a little less fond of the video thing, but she does it, and it's worked well for her practice, and so we're going to keep doing it. But thank you, Steve, for the nice words. A hidden says, could the ALJ, I think you mean ALJ, not AJR, approve me without a hearing? You have a lawyer. Yes, it's called an on-the-record decision, and that can happen. It does happen sometimes, but it doesn't. Sometimes judges are just so busy that they won't get to it. But it's always good to do an on-the-record or at least a pre-hearing brief, which in my opinion is kind of the same thing. So that way, when you are, presenting your case, then, you at least have the theory of your case set out there before. If you're an existing client, call Jen. If you're a new client, I would just go to the SSD answers here and just fill out the form, and we'll get back to you that way. We just try to keep everything kind of in the same process. So it just depends on where you are with us in the process. Peter Protentus, I recently won SSDI, great. Letter says I won back on December 22nd, still haven't received my award letter. And again, this is the same problem I'm having in that these cases are taking a long time to be processed. It should have been done. It should take about 2 weeks, a week, 10 days. The fact that it's been, over a month is a real problem. And I would tell you that if you don't see something in the next few days, contact your U.S. Senator. It should not take this long, but it's taking a long, long time. So it shouldn't take this long, but to answer that question. Laura says, do you know in the initial app if DDS just asked for an adult function form to fill out? It means they'll make a decision soon. Thanks for all your help. No, this is a form they send out to everybody. So, you want to get it back in, but Social Security uses forms, they do it, I think, to partially because they want to get information, but they also partially do it to keep you busy, to think they're doing something. But you got to just fill out the forms, but it doesn't mean they're going to approve you. It just means that, this is part of the process and the case is being worked on, which is a good thing. But it does not mean you're going to get approved. Now that you won my personal car in the app to rent, at the end of the year, will they send me a 1099? No, SSDI is not affected by earnings other than wage earnings. So if you've got passive earnings, rental or something like that, or you got money from some other source, you get a 1099, as long as it is not earnings for work, it'll have no effect whatsoever. But that sometimes can delay things when they see, 1099s coming in from other sources. They have to confirm it's not from work. Jean Russo. I was denied twice for SSD. I got a lawyer, went to court. The judge denied my claim despite my medical records. I'm a disabled veteran. Again, this happens all the time. And again, being a disabled veteran is not binding on Social Security. You don't say how old you are, but, they're looking for very specific things, and it's really about your capacity to function reliably. So you have medical records. Again, I talk to a lot of veterans with PTSD, anxiety disorders. Those are really hard to win. And even if they're approved by the VA, they may not get approved by Social Security. So, different standards, and, you'd think they would use the same one, or they'd give the VA determination some credit, but they don't. So you still have to prove you can't do any kind of work at all. And Jean is 61 years old. So she says here, so that's even more, discouraging that a 61-year-old veteran can't get approved. Now, again, we don't know what the underlying medical problem is, but that is it's discouraging when they don't approve you. And again, if it's mental health, it's because that's really, really hard to prove. Christina says, please hit, I think she meant the like. Matt McGraw says, I waited 3 hours on the phone with SSA. Yeah, this is, the 800 number is just, I understand it's gotten really, really crazy. I don't even call it anymore. As Stephanie Joy said, call to get your DLI. Other things I saw online, you can calculate the DLI yourself. If you get your My Social Security statement, you can do it, because if you look at, and again, it's a little complicated, but if you go to Social Security's quarter of coverage, and I'm going to show you this so you can see what I'm talking about. And actually, if you go, let me just go back where I got it from. there's a page on my website with all these numbers here. And I'm just going to show you that page. So if you go to this page, I'm going to put this link in the comment section here. So here's a link to get to all these tables of numbers, the quarters of coverage, the trial work period, as well as the substantial gainful activity. If you go to the earnings credit page, let me change that over. So I'm going to stop and then go back in and set it up again here. So let's present here and share screen and quarters of coverage. And we're going to go here, and I'll just put this one there as well. So if you know let's say you get your My Social Security statement, and you know that, and let's say you see in, year 2019 where a quarter of coverage is $1,360. 1,360 times 4 is $5,440. So if you have earnings in 2019 of $5,440 or more, then you got all 4 quarters of coverage. So you can mark that down as a 4. In 2020, 1,410 gets you a quarter of coverage. So 1,410 times 4 is $5,640. So if you earned $5,640, you get all 4 quarters. If you earned $5,300, then you got 3 quarters of coverage. So you can go through and figure out your you can figure out if you've got enough quarters. Now, generally speaking, if you have earnings, that within the last 2 or 3 years, and then it's 0 for, let's say, 23 and 24, if you've worked, let's say, $30,000 a year or more, whatever, up until then, there's a pretty good chance you'll be covered for about 5 years after you stop working. So, as a rule of thumb, if you worked, we're in 25 now, if you worked up until, let's say, 2021, 22, you're going to be covered until, 25, 26, 27. So it's a 5-year, because it's 40 quarters in the last, 20 quarters in the last 40, 20 credits in the last 40 quarters, 5 out of 10 years. So if you have earnings of the last 10 years, of 5 of those years, you'll be covered. But, if you only have 5 out of 10 and you've got zeros in the last 5, then your earnings, your DLI is going to probably be sometime in 2025. I know it gets a little bit confusing, but if you've worked up until last year, you're going to be covered well into the future, is what it is. But if you can get that figure or that date last insured from Social Security, you should do it. But yes, if you get your My Social Security statement, you can run the calculations yourself and at least be pretty sure you're going to be covered. I probably didn't do a great job explaining that because it's very complicated. I may do a screen capture video where I actually do those calculations so you can see. But big picture is, if you've worked up until the last couple of years, you'll probably almost certainly be insured through the present, maybe to the next year or 2 into the future. A lot of my hearings, people stop working, 2-3 years ago, and they're insured through December of 26, March of 27. Sometimes it's to December of 24. I've just got to prove they became disabled before their date last insured. And so Matt says, is there any way to get your days last insured online? Not to my knowledge. Again, other than do the calculations yourself using your My Social Security statement. And yeah, it's just a matter of looking at it and kind of guesstimating. All Motors says, how digital hippie, I like it. How often do people get a second ALJ hearing? ALJ wanted some additional expert testimony. Your office was not very helpful in my case. I guess you work with my rep attorney. How does that work? Okay. So generally speaking, if a judge holds a hearing and there's some issue that needs to be addressed, like they want additional testimony from a medical expert, they want more medical records or something, the judge can ask for a second hearing. And it sounds like you're represented, but basically you don't want to change reps at this point, by the way. But I think that it's pretty rare. I'd say less than 5% of the time there'll be a second hearing, but it can happen. I've had it happen. Maybe once a year it happens, once every couple of years, where the ALJ wants a second hearing. And that's just because there's something that was just not determined properly in the first hearing, or it could be that there was a problem with the recording. I've had a few where they had to do a second hearing because the recording was not good, and they have to redo it because of that. So any number of reasons, but a lot of times it's just because they want a medical expert there or they want additional medical evidence. I've had it sometimes where a judge will do it because the person was about to have surgery and wanted to know how the surgery went and had a second hearing 6 months after surgery. So pretty rare, but it does happen. My new lawyer has never seen anyone with a second hearing. Again, it does happen. It's pretty rare. Don't try to file yourself, GC Styles for 24. I will tell you this. People ask me all the time, should I file my own case? And I've talked to or emailed with, I talked to maybe a couple, but emailed 2 or 3, probably 4 people in the last 10 days who clearly have a winning case, compassionate allowance level case, early dementia, some severe neurological disease. And I say to them, look, file your own case. You don't need a lawyer. You don't need to pay me 25% of your past due benefits, although a lot of these cases get approved early enough where there won't be very much money, but just file it on your own. Call me if you get denied. I'll give them the language. I'll say on your application, please evaluate this case under grid rule 12.04A or whatever it may be, or compassionate allowance DI 12345. If you can do it on your own, do it on your own. You don't always need a lawyer. If it's a case that, is complicated with a lot of different medical issues, there's some, complication regarding your onset date, or you don't want to mess with all the forms and all the hassle, I'll do them. We do them all the time. I'd say 30 or 40% of my clients hire me to do the initial application. But I always tell people, if you want to do it yourself, it does not offend me, it doesn't bother me in any way, shape, or form. If you can save the money, I'd rather see it in your pocket than mine. But again, if the one thing I can bring to the party is if I see a case that can be approved early because of the grid rule, because of a listing, because of this new emergency message, I'm going to know how to sort of phrase it where, that gets in there. I can follow up with the adjudicator. So there may be some value to having me do that. But if you can do it yourself and you've educated yourself, go for it. And then hire me, hopefully, or hire an attorney after you're denied. But I don't always agree that you have to have an attorney. I think I think we have value, but I'm not going to say you have to have somebody because you don't always need one. If it's a clear case, your compassionate allowance, you don't need a lawyer. Just go ahead and do it, and they should approve you forthwith. St. Louis Grand. When VEs are determining jobs they say you could do, what factors they look at when finding jobs for people with limitations or interacting with supervisors. Again, the VE testimony, St. Louis, is reflective of what the judge included in the hypothetical. So if the hypothetical said this individual needs to have minimal interaction with supervisors, coworkers, and the general public, or occasional interaction, or frequent interaction, which is less than constant interaction, that would be how the VE is going to answer the question. The VE is not going to assume anything. So, it's going to depend on the question that your lawyer or the judge, ask the VE. So if the question says that the hypothetical person is to have no interaction with the general public and, minimal or occasional interaction with the coworkers and supervisors, that occasional means 1/3 of the day or less. That's what the answer you're going to get. So it just depends on how the judge phrases the question. It's rare that a judge would say no interaction. You might have an incidental interaction, meaning that, maybe once or twice a day. But usually it's going to be occasional, which is like 1/3 of the day, or frequent, which is 2/3 of the day, or constant, which is all day long. But it just depends on the question that the VE is asked. The VE doesn't make that up on their own. But that's, and of course, the less interaction you're allowed to have under the hypothetical with coworkers and supervisors, the fewer jobs that exist, because many jobs require significant interaction with coworkers and supervisors. And if you can have only occasional, that means the job is going to be something where you don't need any supervision. You're working by yourself. things like that. And there are fewer of those jobs out there, but there are jobs out there that would allow for that limitation. But it's going to depend on the question that the judge asks. GC24 says if the attorney doesn't take your case, it means it's a weak claim. You'll be denied most likely. That may be a little bit of an exaggeration, but I would say that if you talk to 3 or 4 attorneys and they all tell you they don't think the case is strong enough to win, that's a message being given. Now, I'm selective. I'm fortunate. I'm pretty selective in what I take. There are some attorneys who are a little bit less selective. They may take a little bit more risk on. It just depends. I mean, I want to take. I do like to take on challenging cases, but I also have been doing this for a really long time. And you've heard the expression, you can't fight City Hall. Taking a case of a 35-year-old with a bulging disc, or a lot of idiopathic pain, which means there's no known cause for it. I may believe the person is disabled, but if I know from 35 years of experience that it's going to be really hard to win, I'm just going to say I can't take that case because I just, it doesn't do me or you any good for me to take a case where it's not likely to be approved. But yeah, I would agree with GC that if multiple attorneys are saying, no, this isn't viable, then you need to get better evidence, or maybe you need to wait till you're a little bit older. It's probably not a great sign. But again, I want to make it very clear. An attorney saying I'm not taking your case is not a decision about the merits of your case. I've seen situations, not a lot, but I've seen them where, I've had people reach out to me and say, I contacted 5 or 6 attorneys. Nobody took my case. I did this on my own and I won. That can happen. So, again, it just depends on, you get a really, a judge that pays high rate, you may get lucky. So, but I would say if you're getting the word from a lot of different attorneys that your case is not very strong, then, that's got to be factored into your decision about whether you want to pursue it or not. Regina Gwynn. I've never seen Regina spelled that way. Very interesting. She notes that applying for SSDI is a very stressful process. Yep, she was awarded last year. She was fortunate she was awarded first application without an attorney. Look, it happens. And again, just like I said, if you can do it without an attorney, go for it. I have no, does not offend me in any way, shape, or form. And if you've got a strong case and you've done your homework, you've looked at my videos, you've listened to live streams, you know how to argue the grid rules or a listing, then absolutely go for it. Tom says, thank you for your AC appeal recommendation. Firm evaluator decided to take my case. Great. And again, this comes in sometimes where people will reach out to me and say, I want to appeal it. And I'll say, here's some appellate lawyers to contact, and let's see if, any of them would think you have a viable case in appeal. And it's not something I can do, but here's somebody who can do it. And there's an example of one where Tom talked to somebody and they took the case. And so he's going to pursue, the attorney is going to pursue an appeals counsel case, trying to get a remand, and hopefully that will happen. So good for you, Tom. I'm glad that worked out. It's one thing about this area of practice is many of the lawyers, not all, but I'd say most of the lawyers here will cooperate. It's not like something where, people are like really, really proprietary about what they know. They share their information. If somebody's talking to another attorney, and they call me, I'll say, look, if you're already talking to somebody else and you've already made a decision, go with that person. I don't steal cases from people. I hope they don't steal from me. It's a pretty friendly bar. I mean, I've gone to the conventions. Everybody's pretty friendly. I'll work with other attorneys. As you know, I'm friendly with Stephanie, with Jeff Herman, with Lisa Palmer, but Joe Huell in Michigan. There's a bunch of people that I do work with on a regular basis. Osterhout's firm. Eric Berger and Lindsay Osterhout. So I like to have these relationships because sometimes there'll be a case that maybe is in their wheelhouse that's not in mine, and I'll say, here, call this person. There's enough business out there for everybody, and you try to do that. And there's a listserv out there that a lot of lawyers that I know belong to, and people post questions. And one of the more common questions in the listserv is, what do you know about Judge X? And then, if you like, I'll answer that twice today. Somebody had, well, what about Judge, X in Covington, Georgia. Well, I happen to know Judge X. So I would say, this is how he does his hearings. He asks for an opening. He asks about work history. He's very pleasant to the claimant, or he doesn't ask for an opening. He's really nasty to the claimant. He doesn't like people who smoke, whatever it may be. The more you know, the better you can be. So this is a nice group of people, generally speaking, who are willing to share information. And that makes it nice, because if I've got a judge I don't know, or if I've got a question, I post it and people will respond to it. And I've, made friends with people through that sort of thing. And I try to answer questions that I can answer. I have people reach out to me on a pretty regular basis. They see the videos, what do you use for this? How should I do that? Happy to answer them. I got 2 emails today from continuing legal education providers. Will you speak? Absolutely. I'll speak to lawyers that are learning about this or trying to get their CLE hours. This is how you do this, and you try to share what you know, like I do in the videos. So yeah, it's a great group of people, and you'll find that sometimes your lawyer may bring another lawyer in, and that's a very common thing. It's a positive, in my opinion. Okay, end of rant. Cindy G. Receive the money or earn it. My company pays me quarterly since part-time only and temp hours depend. I believe it's based on when you actually receive it. So if you got paid in a quarter, that's what's going to count. So if you got paid for 3 months in a quarter, that's going to count as 1 month for trial work period. That's my understanding, but check me on that. That's my understanding, is that it counts on the month you received it, even if you got paid for 3 months at a time. I believe. And that's a very good question. I'll see if I can find more about that, but that is my understanding. But again, check me on that. Okay, Mark Tesden, my client. Mark Tedson, I'm sorry, Mark. Apologize. He's one of my clients. Good morning. Oh, do yourself a good morning. Mark, where are you? Because it is 8:30 at night where I'm at. If you think about going through this process, get a representative. Love the ability to upload visits to the doctor in the portal. Thank you. Yes, we have a portal called My Case. And so when Mark or any of my clients needs to upload something, they just go to the portal, they upload it, we get it, it's in their file, and then we can submit it to Social Security. The records, everything now is done electronically. So when we upload things, we've got electronic access to your folder. Like in Mark's case, I can go online, I can access his electronic folder. I need to upload a record. I attach it, put a little cover sheet on there. It's automatically associated with his file, doesn't get lost, makes life a lot easier than the bad old days when we would have to mail it in or use a fax machine. So now it is all done electronically. But yeah, the portal, and I'll tell you, the other thing is, if you're submitting records to your lawyer or to Social Security, get them in a PDF, one PDF, not 15 pages of, 15-page PDF should not be 15 pages. It should be 1 page. And if you're doing it yourself, make sure you have a barcode on there. If you're giving it to your lawyer, make sure it's readable. Just make it easy for everybody. And so, you want to have all the pages together from one provider, but don't have 15 providers in one packet. You want to have one, Dr. Smith here, Central Hospital here, Dr. Jones here, as separate packets of information, and upload it. Yes, it is evening, not morning. Okay, Cindy, you have no real time to track it. Okay. Are there asset limits for No, there are not. Only for SSDI. That is my understanding, Cindy. It's a month you receive the check. As anything else, that was the case several years ago. I have been under my understanding that is continuing to be the case. But because that is a question that is of crucial importance to people, I'm going to check that. I'll put that on the listserv, and next week I will get a confirmation of that so that I'm not telling anybody anything wrong. So tune in next week. I'll have an answer for you, but I believe it is the week or is the month you receive it. Mrs. K. Hello, Jonathan. I believe I need to contact you when I get an denial letter for recon. I believe my case should be approved. Picture will be 55. Yes, please let us know. We'll be happy to take a look at it. Because again, at 54, 55, the grid rules come into play, and that makes your case a good bit stronger when you're over age 50. All motor. This is kind of write my own brief. You can It's, realize that when I'm writing a brief, I have my own style for writing briefs. There's also some sort of formalistic ways to do it, and that there's services that will do it, and they actually use the 5-step sequential process. So you might, if you're going to do it yourself, download, do some research on the 5-step sequential evaluation process. I think I have in one of my websites some sample briefs. If you want to email me, I'll send you some links of some sample briefs that you can look at. And I'm happy to share that with you. But it's you've got to realize what you're trying to prove, and that is your work capacity. So I don't know if I've got any. I may have some of the. Like I said, there's some services that will do briefs for lawyers. I don't use them. I like to do my own style, but they literally go through the 5-step sequential process, and it's all very formalized, and they do it that way. That's one way to do it. I've got my own way of doing it. But, look at some examples of them and see if you can find something that resonates with you. It's going to be difficult if you're not really familiar with, with all the grid rules and the listings and functional capacity and all that stuff. But, if you want to try, give it a shot. Why not? Bakersfield's 2 or 3 hours from LA. And I realize that. I think that Christina, who's on here every week, I think she said she's in Bakersfield. And if I'm not mistaken, she said there was fire 30, 40 minutes away. Christina, if you're still there, you can tell us. But I know I have a friend of mine in San Diego. He said there are fires there. So, it's, I think there was some rain yesterday in the LA area. So hopefully this is coming to an end, but it's a little scary. After my LJ hearing, I'm at step 4, which again, this doesn't mean anything, quite honestly. It's going to final non-medical review, says medical sign. Good sign the medical is approved. Probably. I just don't, my attitude is that until I have the approval, in my, formal approval in my little hands here, I don't believe it. So I don't care what anybody says online. Until I see it, that I see fully favorable or partially favorable, I'm not going to believe it. So I would just tell you that it sounds good, but until you actually see it, don't believe it. Hate to be that cynical, but I just, I've seen it in situations where it'll say one thing and then you get the decision, it says something else. So until you see it, don't believe it. 50 Blue Z says, worked 35 years. How helpful is that? All through my directors filled out assignment paperwork saying the same thing. That's very helpful. I think that if you have a long 35-year work history, that goes to your credibility, goes to your motivation. People don't stop working after 35 years to sit at home to hope to get Social Security, pay them $2,000 a month. Sorry, my microphone just popped off here. So yeah, I think that is very helpful. And I've had judges literally say to me on the record that the fact that your client has such a long work history is very impressive. So yeah, absolutely, that's a favorable thing for you. Dark Red Beast 99. Thank you for the info. I'm a disabled vet going through the process. The ALJ with the lawyer. Well, good luck. I hope that it works out, and I hope that you get a good result. Chan Tet says, thank you. You're welcome, Chan Tet. I appreciate you tuning in. Miles from Facebook. And I've got a Facebook page, by the way. Go to Facebook and type in Ginsberg Law Offices, and you'll see my smiling face there, and subscribe to the Facebook. We haven't done a lot on the Facebook page, but I'm going to try to do more on it because I think a lot of people are using that as more of a kind of a starting point for when they go on the web. And I think that there's opportunity for me certainly to get the word out a little bit. So I'm going to try to make that Facebook page a little more active. Also Instagram. I've got an Instagram page for Ginsberg Law. Got one for Jody as well, but for me, just Ginsberg Law. I think it's Ginsberg Law Offices on Instagram. Let me just, since I'm talking about it, let me check. Let me see here. Ginsberg Law Offices. Just type in Ginsberg Law Offices, and you will see my Instagram page. And I have got a good number of videos, the shorts on there. I'm putting them on there. And for some reason I can't get, let's see, here we go. see if this will let me log in. I can show you what it looks like. It's not just an Instagram page, but I do have some things on there now. So, just try to, the more ways I can be out there, the better. So I'll just show you what it looks like. So I haven't really done much with it, but there's all these different things you can do online, but let's take a quick look here. This is my Instagram page. So you see a picture of Jody and myself from a couple of years ago. I've got, some of these videos. I'm actually, one of the things I'm doing now is I've got some, different covers. So you're going to see some different looks to this. This is kind of the old way of doing it, but I've got a number of little reels, which are the 1 minute things. And now I'm captioning them. So, hopefully we'll be able to do more of that. So if you can subscribe to it, that would be great. And let me just go to my Facebook page. So you can see that. And let's see here, Ginsberg Law Offices. And okay, let me show you that. Because again, a captive audience, I guess, here. And so that is what my Facebook page looks like. Got to probably change this up a little bit, but again, I've got 2,000 followers on there, which is kind of nice, and excellent page health. And I put there we are right now, the video. So I've just got a bunch of stuff on there. So we're going to try to do a little bit more of that as well. So anyway, if you get a chance to subscribe to the Instagram and Facebook, that just helps me build things up. But yes, Miles, I think that they do count. Okay. If awarded SSDI and they go back 1 year from application date, do they count that back year? And they're 2 years to be placed on Medicare. It is 2 years from the date of first payment. So in other words, if you're found disabled, let's pick a month, October 3rd of 2021. All right. You're found disabled of October 3rd of 2021. The 5-month waiting period does not start in October because that's partial month. November 21, December 21, January 22, February 22, March 22, April of 22 is your first payment, okay? 5th full month. And then May of 24 is when your Medicare would kick in. So it's 24 months after your first payment. I hope that explains the math there. But they go back a year, yes, that does count. So it's based on your onset date, but it's really based on the first month you get paid. So your onset, it could be 5 years ago, but you only get paid 1 year prior to onset. They're going to look at the first date paid to determine when your Medicare kicks in. Jean Terry, almost 65, been in disability for 32 years. What are the chances of being rescinded? 0 to none. It's not going to get reviewed at that point. Jenny Joe says, you wrote a nice review for me and Avo said no. That's ridiculous. So I don't know what the community standards were. I hope you didn't. I don't know what, I can't explain that. I don't know. So if you try again, if you can, or put it on Google, that would be great. I would really appreciate that. Or, there are other places you can go. I think, if I'm not mistaken, let me see if I've got a place here on I've got a personal page. Yeah, I'll just put the link here. I like the Google reviews because obviously Google's the big banana here, but here's a page where there are other places you can put reviews, Justia, Facebook, LinkedIn, Avo, that kind of thing. So, if you want to put it someplace else, there's the place to do it. But thank you, Jenny. I appreciate you making the effort, and I'm sorry that Avo didn't have the good sense to approve your video. I'm not sure what their community standards are, what that means. And Avo, by the way, is a private company. And just so you know what that means, AV, there's a company called Martindale-Hubbell, which has been around forever, and they rank lawyers by their professional skills and their ethics. And so AV is, A in terms of skill and V very high in terms of ethics. So a BV attorney would be by other attorneys rank them. We get these things that come out. What do you think of attorney XYZ? And you fill out, he or she is really good. They're learning or they're not very good, whatever it may be. So if you happen to be AV, and I've fortunately been AV for a number of years, that's the highest ranking you can get. And, you can use that in your marketing and so forth. And, of course, they try to sell you plaques and all that kind of stuff to make money off of it. But, having an AV ranking is a nice little ego boost. So AVO, which is not affiliated with them, I don't believe, they sort of took that AV thing and said, okay, we're going to call it AVO, AVVO. And so that's why, obviously lawyers are aware of that. And AVO is smart. The way they do business is they have a site where, law firms or lawyers can, claim their profile. And then if you get good reviews on AVO, you can answer questions on AVO, all these kind of things. And you can put, like links from AVO, like a profile, like you saw. I think I've got it on my for Social Security. I'll just show you this so you can see what I'm talking about. I'm probably giving you more information than you want, but I'm on a rant here, so I'll show you anyway. You see all this here. These are AVO rankings. I'm ranked 10 out of 10, and Client's Choice Award and reviews and all this nice stuff. Well, the thing is, if you click on this, it takes you back to AVO. Well, this is a link that benefits AVO. So attorneys putting it on their site is giving AVO link juice, which helps their rankings more so than mine. So it's kind of self-serving. And again, I don't mind if they do this because we get the benefit of, I get a 10 ranking, or I've got Client Choice Award, or I've got answering questions, and people do come to AVO, looking for attorneys. So it's sort of a symbiotic kind of relationship, but that's what AVO is, if you're interested, and kind of why it exists. It's a way for them to, and then of course they sell leads as well. So it's all, it all kind of comes down to the almighty dollar. Nobody does anything for free or for their goodwill. I mean, I will say this. I mean, obviously I'm doing these videos. I want people to hire me. A lot of people don't hire me. I'm okay with that. I think it's important to share what I know. But, if I was losing money on doing videos, I wouldn't do them, obviously. So, I think there's benefit to me, and I enjoy doing them. And at this point in my career, it's more about, I like to share what I know, and I just kind of enjoy that. But, everybody's looking in some way, shape, or form to do things that benefit them business-wise or ego-wise, whatever it may be. So I think that's just the way the world works these days. Nothing wrong with it, by the way. Okay. Violetta says, thank you for your time. Wish to help many people. Thank you. Appreciate that, Violetta. Like I said, I think my motivation's in the right place, trying to help folks. Miguel says, thank you for your live stream. It's amazingly helpful. Good. I appreciate that, Miguel. Thank you. And Cindy says, I'm paid out on the 4th of the next month. When does it count? Which month? 11,000 paid in October. I'm paid in November. I would think November is the date on the check, is what I would say. That's my understanding, but I will double check that for y'all, so I'm not giving you bad information. I'm not going to try to pronounce the Carnivo. I got a call yesterday from the rep looking at my case, confirming the last day of my employment. Is that a good sign? Maybe. I mean, I'd have to know more. If they're asking questions about non-medical issues, that's probably not a bad sign. But the other part of it is they may just not have that information and they want to get it. So I don't know that I would go so far as to say that means that you've won. I just don't. You're 57. That helps a little bit. I hate to say yes. I would say a provisional, it's better. That's a better question than other questions you might get. So it's probably not a bad thing. But I don't know that it means anything. I don't know that I would take that to the bank. Steph S. says, I'm 52 and she's failed an anterior fusion, thoracic and lumbar issues, both hips replaced. Had ALJ phone hearing with Lisa Palmer last Friday, possibly 2-month wait to know. Thanks for referring me to Lisa. Great. Lisa is great, very smart. Again, I'm very fortunate. I've got a group of people that I've become friends with, and that if I have questions, I can call them, and they have questions, they can call me. It's a nice community. Nowadays, everybody's working from home. We don't have the traditional law firm model is you go to an office and there are 30 attorneys there, or 15 attorneys, or you're maybe sharing space with 10 or 15 attorneys, and you have questions about something, you go next door. When I first started out, I was in an office suite with about 5 or 6 attorneys. I didn't know something, I'd go next door to Bill or Clarence. What do I do? What do you think? We don't have that anymore because most people are working at home. So the nice thing about making friends through, the online platforms is that now I can call Lisa Palmer, I can call Stephanie, I can call Jeff Herman, or Jeff Herman, he called me last week about something. So, we kind of have our community of people, Lindsay Osterhot, she and I have talked a number of times, Eric Berger, we talked a number of times. They're just people that I trust. I know they know what they're doing. And it's just a nice way to kind of get some, bounce ideas off people because, nobody has all the answers. And, I've done this for 35 years. I learn stuff every week, something I didn't know. Something changes. I didn't know. I didn't know about that emergency message. Walter had it on his live stream, listened to his live stream about it, looked up on Charles Hall's blog, got some thoughts about it, read it myself, talked to some people. I'm able to present to you my thoughts about it. So, I think that's a good thing. So, yes, I'm glad that, Steph, that Lisa was able to help you. And it sounds like you've got a good case. And hopefully you'll get a positive, a favorable decision. Biol, how helpful would it be to include previous inpatient hospitalization for mental illness? Would that strengthen a case? Absolutely. I think one of the indicia of severity for mental health cases is evidence of prior inpatient hospitalizations, especially recent ones, but long ones that are last 4 or 5 years would be helpful. That shows a level of severity. If you have mild depression, they're not going to put you in a psychiatric hospital. If you have mild anxiety or PTSD, you're not going to be put into a hospital. It means it's pretty severe, and that is evidence of severity that I think goes a long way to helping a judge feel like, okay, this is a person that should be approved. So absolutely. Do chiropractic radiology x-ray reports, ask Matthew, hold any weight? After all, chiropractors are not considered real MDs. They're not considered acceptable medical sources. Not every acceptable medical source is an MD. Could be a family nurse practitioner, but chiropractors are considered alternative medical providers, so their conclusions are not given much weight. X-rays in general aren't all that helpful other than to show broken bones. I don't think that an X-ray read by a chiropractor is going to really move the meter too much. The X-ray taken by the chiropractor read by a radiologist, probably better. But I think if you've got a chiropractic physician reading your X-rays and writing out a analysis of it, I don't think that's going to be given a whole lot of weight by Social Security, unfortunately. And I know that I know a number of chiropractors who feel very put out by the fact that Social Security considers it alternative medicine. But that's what they do. And of course, the AMA, American Medical Association, is a very powerful lobby, and they don't want non-medical doctors to be given a lot of weight in proceedings. Now, Social Security did expand what is considered an acceptable medical provider, or authorized, I think it's acceptable medical provider, to include, I know they include nurse practitioners, and they include certain other physicians, but they don't include chiropractors, they don't include acupuncturists, naturopaths, things like that. So again, a radiology report written or evaluated by a chiropractor will not be considered an acceptable medical source. All right, we got a couple more minutes to go. Probably there's no stupid questions, Amy. So do not even think that way. Do we have to get a physical from their doctor, or they take my own doctor's records? They'll look at both. I mean, some adjudicators don't even want to send you out for a medical consultant. They feel like it's not necessary. Your medical records are going to be a lot more important than the consultative doctor in almost every single case. So, do not rely on just their doctor to make a decision whether you're going to win or lose. That's really risky. I think you want to have your own medical providers do it, and in addition to what they do. And a lot of times I use my clients' medical records to offset, to counteract what the Social Security consultative doctor said. Cindy says, thanks for your quick form to be an email, but I'm not ready with research to give you, not ready. Okay, that's fine. And again, do your research, do your due diligence. That's always important to do. I mean, this is your case, and I don't care who the attorney is. Nobody's going to care more about your case than you. So do your own research, be your own advocate, whether it's legal or medical or anything else. You want to be involved in your case and know what's going on. All right, Matthew says, my chiropractic radiology report from 2011, that's right there. That's not going to hold any weight. It's 2011. So several problems with my back and neck, as well as a impingement, which would be causing chronic lower back spasms. Especially if you've worked since then, it's not going to really carry a lot of weight from 2011. Is it marginally relevant? Yeah, if you're going to submit it, not going to hurt your case, but it's not going to make the difference, assuming that it's not a typo. You're talking about 2011. If you had a chiropractor look at your back in 2011, you went back to work and you worked for the next 10 plus years, then you went out again and you're saying, yes, it shows that you had a back problem back 15 years ago, but it was not enough to disable you. It just shows it was a chronic problem. So to that extent, it does show that. But beyond that, it's not going to really help you all that much. M&M. If I was 49 and a half when I applied, I've been waiting 4 years with the grid rules. They will apply. Yes, they will apply as of your 50th birthday. So the first half year, they will not apply. So if the judge was to found you disabled, as of age 49 and a half, you would have to prove you can't do any work at all. As of age 50, you could look at the sedentary grids and they might apply. So the grids will apply as of your 50th birthday. So, if you can imagine a decision being bifurcated, the first 6 months, we're not using the grids, but after that we are. Now there is, I'll just leave it at that. So yes, that would be the situation where you can use the grids as of your 50th birthday. Bert Lay, knew my back pain was going. They waited 14 years before they gave me mine. Keller lied to me for years. My 3 lawyers left and went to SSDI. Lost everything. I'm sorry. People, I have several clients right now that, we won their case and I can't get them paid. I can't get myself paid. So I got, people calling and it's miserable. So, it's just a percentage of cases just get stuck in Never Never Land. I don't know. All right, a couple more questions here. How much does autism affect the decision on top of physical problems? It depends on how severe the autism is and what the functional issues arising from it are and whether they're documented. Have you gone to see a mental health professional? What does that doctor say about it? Simply having a diagnosis of autism does not make you disabled. It's what the effect of it would be. Okay. Let's see here. I'm going to just take a couple more, then we'll continue this next week. Has anyone ever gotten temporary disability due to an Achilles tendon rupture? There's no temporary disability in Social Security. It's got to last at least a year, Rosalind Rose. So if you will be out for a year, you can get up to a year of a closed period, but you don't get like 6 months of disability. You've got to be out for 12 consecutive months. So this is not temporary. Suzanne says the video shorts. Well, good, Suzanne. Again, it's newer. They're faster. They're easier to digest. I'm doing more and more of them. I still like doing the old-fashioned videos, but the market says people want to hear shorts, so I can do them a lot faster, and we're getting them, pumping them out there. So I hope you like them and give it a like, and leave me a comment. That would be great. All right, and Rosalind says, I don't have anyone to help me, trying to figure it out, my bills for 6 months now, even though I cannot work. And this is the problem with Social Security. It's not a quick fix. So unfortunately, even if you have a year out, doesn't mean you're going to get approved real quickly. And there's a lot of suffering. And you're applying for jobs. If you get a job and it's within that year, then your case goes away. Usually, I'm not going to say every single time because there's some exceptions to that, but trial work period and things like that. But if you go back to work within a year and you're able to do it consistently, then you may not have a disability case anymore. Okay, we will leave this with Christina's comments to please like, share, comment, and subscribe. Thank you very much, Christina. Good to see you here. It is great that everybody was here. We got some great questions and comments. And again, if you guys would give me a favorable review on Google or Avo or LinkedIn or wherever you are, Facebook, that would be great. Again, if you need me to look at your case, you're not represented, the link is down there at the bit.ly contact Jonathan 3. And again, send me your questions. I'm going to find out about this question about when the earnings counts. Is it based on when you receive it? I'll confirm that for everybody for next week. I hope you found this all helpful, and we will see you next week. And again, everybody have a healthy and good week, and we'll see you next Wednesday. Thanks a lot.